Thank you, everybody. Good morning, and thank you for joining us for our session today, The Benefits of Including a Charitable Gift in Your Will. My name is Christina Hunter-Kedzier, and I'm the Plan Giving Officer here at the Ottawa Mission. Joining the mission to organize today's webinar are BGC Ottawa, Hospice Care Ottawa, the National Arts Centre Foundation, the Ottawa Food Bank, the Ottawa Regional Cancer Foundation, and the Perley Health Foundation. Before we begin, we would like to respectfully acknowledge that we are on the traditional unceded territory of the Anishinaabe Nation. We offer our gratitude to the First Nations for their care for and teachings about our earth and our relations. May we honor those teachings. Hopefully, you are all comfortable and ready to take in as much knowledge as possible today. Don't get overwhelmed. The session is being recorded and we will share it with you following the presentation. A few housekeeping items. Everyone joining us today is on mute. We do encourage you to type in any questions you have using the Q&A button at the bottom of your screen. We are going to take full advantage of our panel of experts today and answer as many questions as we can. If we run out of time, don't worry. We will reach out to you and follow up after the webinar. So it is now my pleasure to introduce today's speakers, two people today, both with Mann Lawyers here in Ottawa. Heather Austin Scarrett is co-managing partner and head of wills and estates and estate litigation partner. Her practice includes estate planning and administration, as well as commercial and residential real estate work. She has developed extensive experience in the area of estate planning and administration, which allows her to assist clients at some of the most difficult times. She is constantly updating her knowledge as a member of STEP and the Ottawa Estate Planning Council. She is joined by Andre Martin, co-managing partner and head of business law. His practice includes corporate and commercial law, professional corporations, tax planning and reorganizations, business acquisition and sales. Oh my goodness, it's a very long list here. Hold on. Technology law and licensing, commercial leasing, franchise law, financing, private company securities law. Oh, I think we're in very, very good hands today. We are so grateful that you are joining us today, and I will pass it over to Heather and Andre.
Good morning, and thank you very much, Christina, and thank you to all of the charities for allowing us to be part of this presentation to the donor group. It's an honor, and we really look forward to when we can do this in person again. So with that being said, although we've been doing Zoom for 2 years, stuff happens. I'm not great with tech, so fingers crossed, things are going to go okay. We like doing the presentations in person because we like them to be interactive. So as Christina said, please put your questions in the chat. We'll do our best to answer them at the end of the presentation, and we'll assist with the follow-up after the fact if we don't get to everything. So with that being said, we are lawyers, and so we have to say what we're going to talk about today is general material only. It's to inform you to be able to ask questions of your own solicitors as you need to, depending on your fact situation, and this is not going to be legal advice in any way, shape, or form. Thanks. Got to do that lawyery thing. And now I'm working on sharing presentation. There we go. So hopefully everyone can see. Why are we donating? Why are we talking about charities? Well, there is so much going on in the world right now that I think at a very basic level, making a charitable donation makes us feel good. It makes us feel like we have some control, that we can help support programs that are doing good in the world. And so much is needed right now. There's so much going on. It's a very primal instinct to try to help others. As a side benefit, our government recognizes that there is a benefit to an individual making a charitable gift. And so there are generous tax incentives that often go along with particular types of charitable gifts. We wouldn't be lawyers if we didn't then try to define what is a gift. Sounds like it's a simple question. A gift is a gift. Everybody understands what a gift is. No, we can't make it that easy. A gift itself has to be truly voluntary in nature to ensure that the tax benefit that one is expecting to receive is actually going to occur. So it has to be done of your own free volition by you as a donor to a qualified donee, without any expectation that there is going to be any form of benefit or consideration flowing back to the donor for having made that gift, other than the general feeling of goodwill and the happiness that flows from making a charitable gift. So how do you go about doing it? Well, obviously you can make it during your life. You can donate as you go to the grocery store. You can donate when you buy an apple from the Scouts, but you can also make a charitable gift through your will that only occurs after your death. Why would you do this? Well, we never know what's going to happen in our life and what we are going to need for ourselves and our family. And so people are often concerned that they ensure charity starts at home. Sometimes they're looking after their family first, and whatever is left over afterwards can be used to make a charitable gift. Interestingly enough, making a gift through one's will could actually allow for a greater gift to have been made than you could have afforded to do so during your lifetime. And because we don't know what the future holds, if you make a charitable gift in your will, should circumstances change, you can always amend the will by way of codicil or making a new will to change the bequest that you've made, to either increase it or decrease it, provided you still have the capacity, obviously, to make a change to the will. A bequest that you make in a will to a registered Canadian charity can provide a tax credit. Andre's going to talk more about the tax credits later, but it can be up to 100% of the income in the year of the donor's death and in the preceding year. The rules in 2016 changed about when the timing of the gift is made and when it's recorded, but the charitable tax incentive is very good. So when you're thinking about including a charity in your will, what are the considerations? We like to advise people to talk to the various people at the charitable organizations to ensure that you understand what your gift can achieve. Talk to the advisors about the use of the gift, and you can tailor it to your particular wishes to a certain extent by working hand in hand with the charity. So consultation is a big part of the planning that goes along with it. We sometimes get questions about, how do I find the right charity? Well, CRA has a very useful website, and you can review a number of charities on that website that are all registered. When you name the charity in the will, it is absolutely crucial that you use the appropriate legal name, and we always include the charitable registration number. It's important because if you do not use the proper legal name, the gift may fail. Often we'll use provisions in the will to allow for a change of name. So sometimes a charity will change its legal name. It'll amalgamate with another charity. And you don't want the gift to fail because of a corporate decision within the charity itself. So the wills that we draft will often provide for, not often, will always provide a provision that will allow for the changing of a charitable name so that the gift does not fail. One should also think about what happens with that gift. Do you want it to be for a specific purpose, or do you want the charity to have the flexibility to use your gift in whatever manner they think is appropriate based on when it happens and what their programming is going to be? And so we need to be clear in the will whether you want it restricted for a particular purpose or you want to leave it generally open. We always caution that if you provide that the gift is to be used for a particular purpose, then you must also provide an alternate. What happens if that program isn't being run currently? You need to then have an alternative provision for what's to happen with that gift. So again, we're not floundering. The last thing you want to have happen is the estate trustee has to go back to court for a direction about what to do with the gift because the language isn't clear or the intent wasn't clear. That is often, again, a plan that comes about as a result of consultations with the charitable organization. I got ahead of myself. So what happens if you have not passed, but you have run into some capacity issues? Perhaps you have early onset Alzheimer's, perhaps there's some other cognitive impairment. We sometimes get questions about whether or not somebody acting as an attorney for property decision-making for a grantor of that power can also continue the donor's program of gifting while alive. A power of attorney for property cannot change the grantor's will, but they can certainly consider whether or not a charitable gift could be made on the donor's behalf. So while you're acting as a power of attorney for a grantor, you are in what's called a fiduciary relationship, which means you must act in the utmost of good faith with the benefit of the principal, the donor of that power, the grantor, in their best interests. The Substitute Decisions Act is the governing legislation, and it allows, in certain circumstances, optional expenditures to be made. So a gift to a charity would be an optional expenditure, and as long as consideration has been given to the overall wealth of the donor's needs, and the criteria set out in the legislation, it is absolutely possible for a power of attorney to make and continue a gifting scheme that was started by the grantor. It is also helpful for you when you're drafting your powers of attorney to consider whether or not you have obligated or pledged yourself to make particular gifts. And that can be addressed in the drafting of the document, which will make the attorney's job much easier. So when considering whether or not to make the gift, the considerations set out in the legislation will help dictate whether or not the grantor can continue with the gifting scheme. So you can provide for it, as I've mentioned, within the document itself. The donee, the person who is acting as your attorney, should be advised by you of any plans that you already have in place. Makes it easier than them having to go back and look through tax returns to see whether or not there has been a history of gifting. And if you decide that you don't want that to happen, then you can also provide for the contrary within your document. If there is going to be a gift, then the legislation has limitations on what that gift could be. And that's to ensure that there's always going to be support for the grantor and or their dependents as required. So, are you going to do the taxes?
Yeah.
No. So couple more things on taxes. When you die, you're deemed to have disposed of all of your assets at fair market value. That's going to give rise to capital gains taxes, some income taxes, and potentially a state administration tax, which we call probate fees. And I think we're going to do a handoff, very, very smooth handoff.
Yeah, thanks, Heather. Just adjust here. Again, I want to echo your thanks to the participants here today and to the charities that are involved. I also just want to emphasize that Canada is a great country for many reasons, but in particular, it's a phenomenal country for its charitable giving regime and its tax treatment for those donations. So Heather mentioned the 3 levels of taxes that unfortunately we all face when we pass, and the first being the estate administration tax, which is charged on your estate over $50,000, roughly 1.5%, depending on what your estate assets are. Estate assets being largely assets which are solely owned by the deceased or in which there's no designated beneficiary. There's, can you just click forward? Sorry. There's a laundry list in the slide of typical types of assets that pass outside of your estate and therefore don't attract the lovely acronym EAT, which you love tax people, is kind of appropriate, I guess, when you look at how this is being applied. So there are methods to mitigate this type of tax, and we can talk a little bit about that later. But let's move on to the next level of tax, and those are your income taxes, which we're all very familiar with. In Canada and Ontario, it's a graduated rate of tax. So depending on what your income is in any given year, in particular your terminal year, the year in which you have your final return, you will be subject to paying your normal amount of income taxes. Apart from income taxes, as Heather mentioned, there's a deemed disposition of all your assets on death. Valuable, not valuable, that doesn't matter. They're deemed to be sold. And what's interesting here, and what a lot of people don't appreciate, is that although there's a graduated rate of tax applied to what that capital gain is, so the accretion in the value of that asset, that individual asset on your death, there's also a secondary factor you need to look at, and that's the inclusion rate. And you've probably heard a lot about inclusion rates over the last few years in the Canadian tax system from finance and whether or not that would be appropriate to increase the inclusion rate. But basically what the inclusion rate provides for is the amount of the capital gain that you're taxed on, and what that amount will be included in your income tax for that year. Currently, it's 50%, which is not too bad when you think about it. When you have possibly a 50% tax for capital gains and then a 50% inclusion rate, that's roughly 20, 25, 26% of the value will be included in your income for your final year. So as I said, the charitable regime in Canada is one of the most progressive in the world. And to go back to something that Heather mentioned earlier, lawyers, and in particular CRA, likes to define what gifts are. And I'll throw this out here now. Gifts don't include time or donation of time for services. They often don't include property that has little value when it comes to CRA's determination. So kind of case in point, one of my charities that wound down recently had a large collection of literature that they've collected over the years. Unfortunately, from CRA's perspective, it had little value and therefore didn't constitute a gift for this regime. But some of the clear gifts are cash, makes sense, gifts in kind, so securities, stocks, bonds, mutual funds, real estate, the right for future payment, life insurance. That's a really interesting and attractive way to provide for charitable giving. Certified cultural property. So again, we're looking at art, literature, sculptures that are deemed to be culturally important to Canada. And finally, gifts of ecologically sensitive land. Again, sounds a little remote, but one of our charities is in the nature regime and often receives gift of land from its patrons that allows it to fulfill its functions. So
I'm going to interrupt there for just 1 second because I have a real phobia about snakes.
Right.
And early on in my practice, one of our clients had a piece of property that had a preponderance of snakes on it for some reason. And it was a ecologically sensitive piece of land. And they managed to actually get a very significant charitable receipt for gifting it to a particular charity.
The Snake Island.
Snake Island.
There we go. Let me tell you what gifts don't include. They don't include, and we've heard the uproar, through tax shelters or tax schemes. There was a number of them in the past decade or past 20 years. You got to be really careful when you're looking at what you're intending to gift and who you're going to gift it to. So here, Heather also mentioned that actually, before we move on to that, I just want to talk a little bit about what the types of charitable gifts are, bequests. So shares in publicly traded securities, so mutual funds, all of that type of assets, those types of assets. Although taxed at the capital gain when you donate them, there's no inclusion. So effectively, you don't pay tax on that, and you receive the benefit from the charity through a donation receipt that allows you to defer and eliminate some of your income tax, and therefore make life a lot better for your beneficiaries by doing that.
So there's a specific provision that we put in wills that will allow for the selection of the type of securities that are going to have the highest capital gain to affect the gift to the charity.
Absolutely. The other is art. We are all, well, except me, artists of some sort, and we surely feel that art is valuable. From the government's perspective, your own inventory is not something you can donate unless it's actually certified to be culturally important. Real estate is interesting. Again, there is a capital gain that you'll incur in your real estate bequest. However, if it's ecologically sensitive land, there's no inclusion of that capital gain in your final year. And also just be mindful that if it's your principal residence, although that applies in terms of its deduction, so you don't have to pay tax, that only applies up to date of death. So any increase in value after date of death could be taxable at the capital gain rate. Finally, insurance. Insurance can be either purchased by yourself with the charity as a beneficiary, which is fantastic. Just note that the actual payments to the insurance company, those are not tax deductible. However, if you have insurance in the name of the charity and you pay those fees, those are tax deductible. The final bit, and not get too far in the weeds here, is, if you are doing this through a private corporation, there are special rules that apply with that insurance. So definitely something to talk to your advisors about. All right, so we talked a little bit about gifts. Now we have to talk about to whom these gifts can be made. And Heather mentioned earlier, registered charities, that's, or other qualified donees. Qualified donees include registered Canadian Amateur Athletic Associations, National Arts Services, universities, all levels of government, and now the King. Though I don't believe he needs your charitable donation, you may well want to donate to the King. The rub on all of this is that they are registered and they are recognized by CRA, and that's really important because that organization has to be able to give you a donation receipt in order for you to be able to claim the donation in your tax return and reduce your income taxes.
And effectively, Canadian registered charities, if you have a charity in the US as an example, not to throw a question at you in the middle of your presentation, but
they still need to be registered in Canada,
right,
regardless of where they are. And as many people know in this area, there are charities that span the globe, and they are registered in each jurisdiction to allow this receiving and to allow the system to work as it's supposed to work. Okay. So I just kind of jumped ahead here, but basically what happens once you donate your property, assuming that, again, you've had that conversation with the charity, it's property that they would like to have, they can use. Real estate being a good example, some charities just can't absorb that type of asset. What will happen is you'll receive a donation receipt, which will be at the transfer value of that asset, and that'll be used not to reduce, it's not a deduction to your income tax, but it's a credit system. So I mentioned at the beginning of my talk that Canada has an incredibly beneficial system, and that's found in its credit credit system. So basically, you get a refundable tax credit that's applied against your income, and that reduces your overall tax burden, which allows you to bequest more to your beneficiaries, and win-win. You get to do great things for charities and for our country, which is a phenomenal thing in this country. The system works basically on a kind of a graduated rate. 15% of the first 200, 29% of the second 200, and if you have income over 200,000, it's 33%. The calculations can get a little complex, and then there's matching provincial calculations as well at 5 and 11%. Effectively, at the end of the day, you're looking at maybe 40, 45% in terms of credits, which is just amazing when you actually crunch the numbers. If you go through kind of an analysis and let's say shares, for instance, if you sold your shares at fair market value and you took that money and donated that money, you'd actually be losing money by doing that versus donating the actual shares to the corporation. So mathematically, this makes great sense, and it's a real benefit to not only to yourself, to your family, but to the country. And that's basically it for the presentation on my end. We can get into more detail in terms of mitigation and in terms of EAT, using alter ego trusts, using dual wills for private corporation assets. We can also discuss foundations, which we do a lot of at this firm, but I think that's probably the subject of a good hour conversation, and we'll just keep this kind of short and sweet and at a high level so we can answer any questions.
Great. Well, I must say, every time I hear you guys speak, I learn something new, and I'm just always blown away at the amount of information that you can pack into a presentation like this. So thank you for that. And we do have a couple of questions that have come in. So first one, I'll start with a tax question since we're just hot off the heels of Andre's presentation. In order to reduce tax on my estate for my heirs, is it best to make bequests to charities in my will, specifying they will come from securities with the highest value added? I think one of you may have kind of touched on that briefly.
I tried to talk about that, but Heather jumped in, so I'll let her jump in again.
So often what we do, as long as this provision's been around, I don't know how long, at least 20 years probably. So what happens is you give your executor the provision in the will that allows them the power to make the gift by looking at what assets are in the deceased portfolio, and then allocating the assets that would have the shares that would have the highest capital gain to fulfill the bequest. So if you want to give a charity a bequest of $100,000, then the estate trustee could work with the financial advisor and say, okay, of the stock portfolio, which shares are going to have the highest taxable capital gain that add up together to about $100,000, and allocate those to the charity.
Okay,
wipes
perfect.
out the gain essentially, and you get the charitable receipt for the estate.
Okay.
So it's hard to dictate that ahead of time. I had one client who had a Berkshire Hathaway share, one, and it was worth oodles. And so we actually, instead of giving the latitude to the estate trustee, bequeath that particular share to that particular charity. That's a very rare circumstance. It's better, I think, to generally have a provision that allows the flexibility.
That makes a lot of sense. And I was actually, while you were talking, thinking about that, right? Should somebody say, my Apple stock, or name a specific stock? So
the risk is that a will speaks from day to death. So we never know, you might have had to sell that Apple stock. There may have been a good reason to have done so. So if you are too specific, then excuse me, then the gift itself could fail if it no longer exists.
Yep.
And if you are specific to the stock, then the executor doesn't have the choice to go out and buy another stock to replace it.
Right.
So you have to be careful about that type of planning.
Perfect.
Some of the other issues for direct bequesting, I think one of the questions came in before the presentation started, excuse me, is whether or not you should consider gifting your RIF or your RSP directly to a charity. So naming the charity as a designated beneficiary on those types of registered plans, or the tax-free savings account. So let's talk about the ones that are going to attract tax first. If you have money left in a RIF or an RSP on your date of death, and you do not have a qualified beneficiary to whom it can roll over to, then the value of the registered plan is brought into income in the year of death, and you're taxed on it as income, because anything earned on it up until date of death, the tax has been deferred on it. So it comes home to roost. So if it's brought into income, then your estate is going to pay the tax. If you designate a registered charity on that plan, then the money from the plan goes directly to the charity. The estate gets a charitable receipt. The income is not brought in for tax purposes, and it's passing outside of the will. So there's also no estate administration tax.
Nice.
So we're seeing more and more of that. The catch is you have to be very careful about identifying the charity. So the same problem that we have when we draft in a will, if we haven't properly identified the charity, we have a problem. At least if it's in a will, we have potentially a saving provision. We have remedies at law where we can apply for rectification. If the gift is named in the plan itself, if the charity is named in the plan itself as a designated beneficiary and it's wrong, that gift could fail. The institution that holds the plan will not be able to pass it to the charity, and litigation will likely ensue. It would fall into the residue, and that's not a good situation.
Yeah.
So again, checking, making sure you've got the proper legal name of the charity. If you learned anything today, that's the important thing.
Excellent. I like clear takeaways. This is good. This is good. So next one is an interesting one. If I was interested in setting up a scholarship upon my death, is there a tax benefit, or is it just a charitable donation?
That's a really good question. It's off the cuff, which is never a good way to answer. I think you have to deal with the institution for setting up the scholarship first to make sure that the parameters are clear. If you're doing it in your will, it can't be void for public policy reasons. So it has to not be contrary to any of the charter issues that might come up. So we've seen some cases out of New Brunswick where there was, it's not a scholarship, but a gift to a neo-Nazi organization, which failed at law because it's void for public policy reasons. So we've also seen some cases where I think there was a scholarship that was only for women, and there was a problem with that. I'd have to be checking on that one. So you have to check on the language of the scholarship, and then you would have to, I would think, go through some analysis with CRA to see if you could get a tax receipt for it. I think it's possible, but not without some good background digging and planning.
You would work with the institution itself, and they would have a program to be able to assist you. It's tick all the right boxes, and you should be fine. Absolutely.
Yeah. Very, very another good takeaway too, right, is talk to the charity to make sure your wishes are crystal clear, and we will take good notes so that, when the time comes, everything is there and documented. So I
mean, that's important both for the use, but also sometimes family wants recognition that you're going to make a donation because you're memorializing somebody, and it's so important. And if you can do that in a fulsome conversation with the charity, then everybody wins.
Yeah, exactly. So another good question, can I have a provision in my will whereby my executor can decide to make charitable donations from the estate without actually naming a specific charity?
You can. It's called a power of appointment. And I sometimes get this question because clients will say, I give to different charities every year. Like my intent changes. And so you can. It's not my favorite way of drafting. If you have charitable intent and your ideas change over time, then sometimes looking at one of the umbrella organizations where you can have an agreement, a donation agreement ahead of time, like with Community Foundation as an example, and they can manage it. So it can be for different purposes with different charities. So it's possible.
Good to know. This is another good
Really
one.
Good questions.
I know, right? We have very, very smart donors here.
Everybody had coffee.
Thoughts on CanadianLegalWills.ca or other online will creating places that are popping up so much these days?
There's a lot of them.
Mm-hmm.
So it's a useful tool to start helping you think about what to do. If you draft it, then you're responsible for it. If I draft it, I'm responsible for it. If I make a mistake, there is an insurance program behind me. If you make a mistake using the program, then my estate litigators will make use of that document and will be fighting over it. So if you're doing something really simple, a holograph will, which costs nothing, it's in your own handwriting, it does not get witnessed, it gets dated, it gets signed. If you're going to do a do-it-yourself thing, I would recommend a holograph will over a stationary will.
Interesting. Interesting. Huh.
There's also, after we came through pandemic, I'm not sure we're through. There's new protocols about signing wills. BC has brought in legislation to have fully electronic wills, signed electronically, blockchain analysis. If you wanted to amend that will, you have to do a new will. There's no codicil program within the electronic registration signing protocol. As I understand it right now, that may change in the future. If you do a stationary will, and the tendency that I've seen that we've litigated is to then make a handwritten amendment to the document. So now you've got a document that's pre-printed with fill in the blanks, with changes to it. It becomes a challenge sometimes to interpret. Banks don't typically like them. So you might have gotten away without probate with a will prepared by a lawyer. You are unlikely to do so with a will that's prepared on a form. So my 2 cents.
Interesting. Yeah, definitely interesting.
Google is fantastic for many things.
Yeah.
Just generally speaking, for law, not so great. Because of, if you look at where the sampling is coming from, it's all over the world. It's people interpreting our laws, and it's never really fulsome. My wife goes on Google to look at, I call it Dr. Google if something goes wrong. And like, please don't look at Dr. Google. We have a doctor to go to, because you just end up going down a rabbit hole that you don't need to, and live with that kind of anxiety and that doubt. And there's no real reason to have to do that. So
sometimes the benefit is in having the conversation. Much like we recommend having the consultation with the charity that you're considering, sometimes what evolves from the conversation I have with the client as we're talking about what their wishes and their plans are, things change completely. And sometimes not. I had clients in the other day and they had double wills. So private corporation, they're complicated. They didn't understand what was written. And I get that. And I think that that's a big motivator behind trying to use the stationary wills. They're perhaps written in more plain English. From my perspective, the client has to understand the will. It's your document. You must understand it. I'm visual. So although we put a lot of words in our wills, my wills always start with a drawing. And arrows and circles and where are things going, so that you can get a one-page snapshot of what this sometimes difficult document is to read.
Yeah. No, very, very, all really good points and things to consider. And I love that idea and the visualizing it and making a drawing and a picture, and that makes a lot of sense. And I'm going to go home tonight and draw a picture for my will.
You can't see this right now, but the room we're in, one wall is a whiteboard, the entire wall. So when we did our offices, I insisted that at least 3 of our boardrooms had white walls, because when we're able to see clients in our office, that's what I do. I chart it on the wall. So.
Yeah, that's really smart. Really, really smart. So next question, where the beneficiaries are all family members and a simple estate, no real estate, is there a requirement to probate the estate?
Oh, I'd love that question. And you're going to get a lawyer answer and you're going to hate it. It depends.
I knew that was coming.
So it's generally speaking, it's the third-party institution holding the asset that needs to be comfortable with the documentation, and they can decide whether or not probate's required. So if you have the deceased person had 800,000 in one of the 5 big banks,
Right.
and spouse is dead, and the estate is going to be divided between 4 adult children, and all 4 are executors. Crazy example. Then I would suggest the executors have a meeting with the bank and ask what will make the bank happy to avoid probate. If there's no other assets that need probate and that's the only asset in the estate, there are documents called a declaration of transmission and an indemnity agreement. And that essentially has the executors promising the bank that in consideration for the bank releasing the assets to them in their capacity as executors without probate, if some other beneficiary comes out of the woodwork with another will and says, oh, no, I'm the love child, I'm the one who's supposed to receive all of the 800,000, bank, you did something very wrong by giving it to these executors, please pay me the 800,000. The bank will turn to the executors looking at the indemnity agreement and say, I need that $800,000 back.
Right.
Now, that's simplistic. There would be litigation, but yes, in theory, it can happen.
Yep. No, that makes perfect sense. So a follow-up to that, do you advise use of joint accounts with trusted family members to avoid probate taxes?
I do not. So after 2015, there's a new requirement to file something called an estate information return. And if an adult child is joint on an account with a parent, then the case law says, absent evidence to the contrary, that account is held as a trust for the benefit of the estate.
Okay.
It's called a resulting trust. So if an asset has to go to if an asset causes the estate to be probated, then the money in that joint account should also be included for the purposes of calculating estate administration tax.
Okay.
That being said, if there's no requirement to go to probate, then there's no requirement to file an estate information return.
Okay.
So the executor will not then have to swear an affidavit, not including all of the assets of the estate.
Okay. Like frantically
so once again,
writing notes here for my own personal,
Yeah.
I'm currently an estate trustee right now too. So I'm like, okay, yeah, definitely not an easy, way of avoiding.
I think one of the other keywords in that question was trusted.
Yeah.
And so sadly, we have an estate litigation department. Why do we have an estate litigation department? Sometimes you can't actually trust. Yeah. Yeah. And sometimes it's just misunderstanding. So there are other things you can put in place. So if you intend it to go to the child who is the joint account holder, then you should reflect that in the will. And then even though it's there, it's a gift, it's intended to pass by right of survivorship, and estate administration tax will not be calculated on it. It's an excluded asset.
Right.
But if you intend it to be shared, then everybody should know that. So there's no confusion afterwards, and you have to deal with what the laws are.
Yeah, no, all very, very good points. So, all right, next one. What changed post 2015 with regards to charitable gifting? Do I need to rewrite my will if it was prepared before 2015?
So a couple of things happened. The 2016 budget changed the taxation rates and brought in the graduated rate estate. So there's a 3-year window when the tax on an estate is based on the marginal rates instead of the highest possible tax rate. And there was also, I just lost my train of thought, the inclusion of the charitable gift changed. It used to be that you could include the gift that was going to be made to a charity in the terminal return. And after 2015, it's when it's actually made. So it would be filed with the T3 trust return, or you do an amended T1. I'm talking accountant speak now. So it effectively changed when the estate gets credit for the charitable gift. You don't necessarily need to rewrite your will, but you should probably have a look at it just to see if you want to have a provision that gives the estate trustee the flexibility of keeping the estate going for the 36-month period after date of death when it's a graduated rate estate.
Right. And that's a really good point, right? So you may not necessarily have to rewrite, but you should review it and just double check that everything is still the way you want it. And yeah,
absolutely. Every year when you're doing your income tax, at the bare minimum, it's like, good physical hygiene. Go see your doctor once a year, review your will once a year. Yeah.
Change your smoke detector battery.
Yeah. all of it, all at the same time.
Yeah, exactly. Little checklist, right? Things you need to do. So what are the requirements for an estate to be probated? And I think, Andre, you may have mentioned like the minimum, like if it's above the value.
There's a you can talk about this, but there's a de minimis level of an estate.
I think they're asking about when, though, what triggers probate. And so real property held in one person's name alone, if that is an asset owned by the deceased, subject to a first dealings rule, that would trigger probate. Once one asset is caught for probate, then anything that the deceased owned in their name alone has to be valued. And then probate tax is paid. You file the application, you get your certificate back, and the estate trustee then runs with it. There is no estate administration tax on the first 50,000. It's called a small estate. So there are now special rules about processing a small estate. It may still require probate. So if you had $40,000 in the bank and you didn't have a will, you would have to apply for a certificate of appointment of estate trustee without a will. If you had a will and you still had $40,000, but for whatever reason the bank was insisting on probate, then you would still go to probate, but you would not pay the estate administration tax.
Okay, that's a really good guideline, right? So like lawyers speak, it depends. That's why,
Christina.
There's the next takeaway.
Yes, exactly, right? So great. Will I get a tax receipt for any charitable gift? And I think, Heather, we were kind of talking before we hit record too, right? So if you want to give a charitable gift, but they're not a registered charity, like how can you speak a little bit about that and how that works?
So some of our clients have causes that they like to support, but for whatever reason, the cause has decided not to register as a charity. It's a not-for-profit. And so we can still leave them a gift in the will. The estate just will not receive a charitable tax receipt because it is not that type of gift that is going to benefit from the tax laws established to help charities.
Right. So it'd be the same thing, leaving a gift to a loved one or a neighbor, that it's still a gift, but
Yep.
you're just not getting that tax benefit. So it is
Correct.
still eligible. Yeah.
And as
And-
Andre spoke about, it depends too on the nature of the gift. So if I wanted to donate Andre's shoe collection, then that probably isn't going to attract a charitable receipt, even if it went to a registered charity.
Oh,
Right.
come on now, Heather.
I'm sure your
It
shoes
would
are
in-
awesome,
it would in
Andre.
Italy.
Oh,
my
goodness. We've got one last question here, but please feel free to keep sending in questions. We do have our speakers booked for a little bit while longer. But this question came in: can I sell a designated security? If so, do I have to revise my will?
You spoke about that.
Yeah, so you can sell your designated security during your lifetime. If you put the cash that you receive from that into one of your assets, then it is going to be covered by whatever your will says as at date of death.
Okay.
If the security was specifically bequeathed to somebody or a charity in your will, then that gift no longer exists and the provision in your will fails. You don't have to rewrite your will for that purpose, but it just won't happen.
Right.
It's just not
There
there,
may-
not there to give.
It's not there to give. So
Right.
same thing happens, you give away your diamond ring, but you lose it 3 months before you die. The executor doesn't have to replace the diamond ring to give it to the beneficiary. The gift fails.
Right.
So if that's a possibility, then we have a discussion about it and we draft around it. So if you, there's this thought about tracing. So if, for instance, you were gifting a house and it was sold before death, there may be a claim by the beneficiary to have the proceeds of that house flow to them, depending on. So this comes up often when you're talking to powers of attorney about managing the assets. So a power of attorney for finance, for property decision-making, is supposed to review the grantor's will.
Right.
And they are not to deal with assets contrary to the terms of the will. So we have a file now where our client is never going to return to her home. She is incapable. The property she owns is specifically bequeathed to a named beneficiary. It is costing her to keep this property that she's not going to return to. So with the consent of the named beneficiary, we are going to sell that property, but keep the funds invested in case they're needed for her care. But we have to use other assets before we can turn to this asset. And on her death, the amount that has been set aside based on the disposition of that asset will be earmarked for that named beneficiary.
Yeah.
Convoluted answer to what seemed like a simple question. It's not a simple question.
But that's a great example, right? Of just, keeping the person's care and well-being in mind, but also,
Balancing.
The wishes of that person after they're gone too. So no, that's a great example. So you mentioned, we talked a little bit about designating a beneficiary, like a charity as a beneficiary for your TFSA, your RIF, Is that enough, right, to name a charity as a beneficiary? Or should you, you've informally told the charity about these arrangements, but are there other steps that you should take, right? And in this specific question, the person at this time, they're not prepared to make a will or name an executor, but they've got the beneficiary named for their TFSA. So can you speak a little bit about that?
Yeah, I would check with the institution itself to make sure that you've used the appropriate form to name the beneficiary. I would confirm with the charity that you've got the proper legal name of the charity. If the form itself or the designation happens, probably doesn't have any space for creative writing to say what it's for.
Right.
So you're not going to have a purpose on there. So if the charity receives it, it'll be for the general purposes of the charity. It'll happen faster than having it go through the will because it's a designation. So the executor would have to provide the institution with the death certificate. So it would be helpful for this person who doesn't want to make a will. There needs to be somebody who's going to inform the institution that the person has died.
Mm-hmm.
So somehow that death certificate needs to get there to start this process in motion.
Yep.
So if there are lots of funny rules about not having an executor named and then who has the right to step up to do that. So you can be, it's an executor dissentor. So my French is lousy, so I apologize to any of our French listeners. But executor dissentor is somebody who steps into the shoes of an executor without having the paper to support it and takes steps to administer the estate. It's a very dangerous position to be in because you can become personally liable for things without having any official capacity. So I appreciate that the person may not want to make a will. It doesn't have to be a complicated process. Not all of our wills are double wills dealing with corporate assets.
Yep.
No, it can be a very simple thing to do in combination with the designation of the charity on the tax-free savings account. So then we've got the person who is going to be dealing with funeral, even if there's a prearranged funeral. Again, somebody still has to inform the funeral home.
Yep.
You need somebody to get that death certificate going.
Yep.
And if it's not under the will, then the Succession Law Reform Act says who gets the right to apply to step up as executor.
Yep.
And if nobody is either in the province or available under the hierarchy of who, then the public guardian and trustee might step in.
Yep.
And that's a long and tortured process. It's a government office. They're underpaid, understaffed, overworked. So the kindest things sometimes you can do for your family or whoever it is that you intend to benefit with your assets on death is to make it as simple for them as you possibly can.
Yep. And like you said too, right? A holographic will can be very, very simple and, just making it everything crystal clear to move forward.
If you can, at the very least, if you're not willing to go to see a lawyer, then I would encourage you to do that. There are some good blogs about that. Make sure you're looking at something Canadian. The biggest problem we see with holograph wills is somebody feels that it's going to be advantageous to have them witnessed.
Yeah.
Don't do that. If you have a will witnessed, then you bring it into the legislative requirements for the formalities of execution of wills. And there's one good thing that came out of the pandemic. The legislation changed. Ontario, until the pandemic happened, was a strict compliance regime. So if you failed in the proper execution of a will, a witness forgot to sign, a pen change wasn't initialed, then the will itself may fail.
Right.
Ontario became, because January 1, a substantial compliance legislation jurisdiction. So if you are substantially compliant with the provisions for the execution of a will, then the will not necessarily be held to be invalid, but it may require a court application to have it proved. So there's some risk with do it yourself.
Try not to go there.
Definitely. Next one, great question. And again, our key takeaway, make sure you have the charity's, proper name.
Yeah.
But what happens when a beneficiary can't be located, whether
Oh.
it's an individual or a charity? What
Yeah.
happens to their portion?
So if you haven't considered that at the drafting stage, so that's the first thing. If you have, and some of our clients have estranged family members who have had addiction issues or other mental health issues that keep them from being in constant contact with the family, and they don't necessarily know where they are, and they come in and out of lives. And that's a reality, and we have to face that and be open enough to find a solution for dealing with it.
Yeah.
So we can either provide a time period within the will. So there's a mechanism to say, if not, then this is what's going to happen. If there's no provision in the will, then you have to go to court to show that you have exhausted essentially all efforts to be able to locate the person. Then you either have an arrangement to pay the bequest into court, or you get something called a Benjamin order for essentially some form of a substituted service and protection of that asset in court. So
Yeah.
it doesn't happen very often, but there is a mechanism for it.
Yeah. Yeah. And so a follow-up question to that, so that's more an individual, but what if the charity that you've named in your will isn't around anymore? What happens then?
So similarly, if, again, when we draft for a charity, we talk to the client about the what ifs. Wills are always about the plan B, plan C, plan D, depending. And so the clause that we typically use will allow for the gift to go to a charity that's carrying on similar purposes and objects as the one that was originally named, unless the testator or testatrix decides otherwise. So if that particular charity is no longer in existence, then we pick a substitute and name the alternate.
Yeah, that makes sense. That makes sense. How much does your firm charge to draft a will for a couple?
That really depends.
I knew you were going to say
lawyer
that.
answer, Heather. I'm spending too much time with you.
Yeah. We have discretion, obviously, to do stuff pro bono. So for people that really can't afford but need to have something in place. And then we draft complicated wills that Andre's got, half a dozen professional corporations for the clients and holding companies, and we've got US beneficiaries. So that's not an easy answer. There is a range, but the person could email directly and we'll talk.
Yep. Perfect.
Yeah, we let them know before. It's not a sticker shock at the end.
Yeah.
Sort of give an idea. And we sometimes don't know until we get into the complexities of it.
Right, of course.
I'm a maritimer, so I like to keep things simple unless they can't be simple. So
yeah, for sure. Here's another great question. I have 2 children. Is it still beneficial to add a charity in my will?
good question. So it depends on where in your will you think you might want to add the charity. So some of our clients find that their portfolio is such that their children are going to be fine, and we add a charity for a specific bequest before the residue falls to the children. Sometimes the children are young and we don't know what's going to happen, and so the client will provide for a trust for the children to a particular age, and if the children were both to die without having children of their own, then we have a charity involved. So it depends on what you're trying to accomplish. If you are looking to offset some perhaps tax consequences that might otherwise result in less money going to your beneficiaries, you can accomplish both goals by making a charitable bequest and ensuring there's sufficient assets for the family.
Oh, that makes sense. And are there also, you can also use a provision that, if everybody passes away, like you're on a family vacation, right? Can you talk a little bit about that too as an option?
So we call that our family disaster clause. So if after you've worked through all of the provisions, naming whoever you have as beneficiaries, and there's still assets left over, then to avoid what's called an intestacy, where you have assets without any instruction in the will as to what to do with those assets, we put in the family disaster clause. So if everything else fails, then this charity or these charities are going to share in whatever it happens to be that's left.
Yeah.
And I think that's a nice way to cover off all sorts of possibilities. And that can be done in conjunction with a fixed gift to a charity. So you can do a cash bequest to a charity. There's still lots for family members. And then you have the charity again at the end in case all of your great planning fails. No one expected the pandemic. We don't know what our future holds. So as I say, wills are really plan B, plan C.
Yeah, definitely. And just something that popped into my head that I get donors asking me about is codicils, right?
Yeah.
So you've got a rock solid will. It really doesn't need to change, but you've thought, it's been a couple years, and a charitable gift in my will is something that I'd like to do. Do you rewrite? Can you do an add-on? How can you manage that?
Good question. So a codicil is an amendment to the will. It's usually very simple in nature. So we often use it to change an executor, for instance, but it can also be used to make a gift. So if you haven't done the family disaster clause, you could do that by way of codicil, or you could insert, if you've left a number of cash bequests as legacies. So you have A through H family members, then you can add I through L as charitable bequests. That's possible.
So
if
excellent.
It's going to be a change that is so integral to the dispositive scheme, so the trust arrangement or the gifting arrangement that's already in the will, it may require a full redrafting. It just depends on how the will is laid out.
Yeah.
And whether or not other changes are necessary.
Yeah. So again, review it, take
Always
a look.
review
it. Yeah.
One of the things that happened January of this year, pandemic has done a number on my sense of timing. It used to be the case that wills could be rendered void by virtue of a marriage. And so I would often see codicils to say, my will is still valid even though I went and got married, if the will itself had not been made in contemplation of marriage. So as of January, that legislation changed. A marriage in Ontario no longer renders a will void. That was huge. And that came about in part because of a trend we were seeing in predatory marriages.
Oh,
yeah. Whole other session. But the legislation has been helpful.
Yeah, sign me up for that one when it happens. Okay, I feel like that would be very, very interesting to hear about for sure. Can you speak a little bit about the benefit of life insurance to offset the difference between a gift, so a loss of an asset, and a tax receipt advantage to the estate?
All right, so sometimes we have assets in the estate that are going to need to be realized to pay the capital gain. So cottage is a good example. There's not sufficient cash in the estate to pay the capital gain, and the family doesn't want to dispose of the cottage. So often insurance will be used as a tool to flood cash into the estate to be able to pay the capital gain, but it can also then be used to make a charitable bequest, which will help offset the tax based on the credit system Andre was speaking about. Perhaps that's what they're getting at. So that takes, when we do these more complicated plans, this is why we're doing the presentation together. So we often work together to help the client figure out what the best plan is going to be to achieve the overall goal, working with their advisors and their accountants as well.
Yeah, exactly.
And charities.
Yeah, it takes a village.
It does. Yeah, for many things. So I think that's what the question is getting at.
Yeah, For sure, for sure. So we have not a question, but a comment of gratitude for how clearly and articulated things have been explained. So I hope that you know, that's not just one person feels that way, but I know definitely, as I said, you know, after your presentation, before we did the Q&A, I always learn something different and something new. And, you know, these Q&As are great too, just to kind of, you know, really what people are thinking, and everybody's situation is so unique. So it's great. It's great. And I think we're pretty much, yeah, Delphine is nodding her head. We have no more questions. So I guess we will wrap up. And I just want to remind everybody who logged in today that Heather and Andre did very graciously volunteer their time this morning to prepare and present today. And we're just so very, very grateful to you for that. And in recognition of that, we will be sending along a gift card to each of you for Canada Helps. And you will be able to make a charitable gift to the charity of your choice as a way of us saying thank you so much. And yeah, that's about it for us. And again, thank you to all of our donors and people who've, you know, signed in today. We hope that you found this helpful, and thank you for supporting the charities that are important to you and close to your heart. It really is, you know, special, and we're just grateful for everybody to join us today, and hope you have a great rest of the day today. Thank you so much.
Thank you, Christina. And thanks, everybody. Great questions. Till next year. Bye.
Yeah. Bye-bye.